report on the 2019 revised rules on evidence. Evidence Rule 132, Section 33 to 36. Section 33. Documentary evidence in an unofficial language. Documents written in an unofficial language shall not be admitted as evidence unless accompanied with a translation into English or Filipino. To avoid interruption of proceedings, parties or their attorneys are directed to have such translation prepared before the trial. In this section, there is no revision. As a general rule, documents submitted in court which are not written in English or Filipino is inadmissible as evidence. The two official languages in the Philippines as provided under Article 14, Section 7 of the 1987 Philippine Constitution are Filipino and English if provided by the law. In the case of People versus Tumakin, the Supreme Court held that if an affidavit is executed in an unofficial language, the court has the discretion to deny or give the party the opportunity to secure a translation of the affidavit. Meaning, Section 33 is not absolute because the court has the discretion whether to deny or accept the document written in a language other than English or Filipino. So it is a case-to-case basis left in the wisdom of the court. So here is a question still in the case of People versus Tumakin. Is a document written in Cebuano admissible in evidence? As a general rule, the answer is no. Documents written in an unofficial language shall not be admitted as evidence unless accompanied with a translation in Filipino or English. However, there are instances that the court may consider the document. Let's take a look at the question in the next slide. Okay, this is still in the case of People versus Tumakin. The question is, the trial court took into consideration accused extrajudicial confession in Cebuano in convicting him. On appeal, the accused contends for the first time that his confession should not have been received in evidence pursuant to Section 33. Is the accused contention correct? The answer is no. Accused extrajudicial confession in Cebuano should have been translated by the official interpreter of the court or a translation agreed upon by the parties and both the original and the translation filed. Strictly speaking, the extrajudicial confession should have not been admitted by the trial court as evidence. Kasi nga po, it should be translated in English or Filipino. However, considering that the accused did not interpose any objection thereto during trial, and the parties and the judicial personnel appear to be familiar with Cebuano, the extrajudicial confession was properly considered by the trial court. So hayan po, the trial court accepted it. The doctrine of this case is that when there is presented in evidence an exhibit written in any language other than the official language, if there is an appeal, that exhibit should be translated by the official interpreter of the court, or a translation should be agreed upon by the parties and both original and translation sent to this court. In this case, there is no official translation of appellant's extrajudicial confession in the Filipino or English language. If the court were to strictly follow the rule, then appellant's extrajudicial confession should not have been admitted by the trial court as evidence for the prosecution. Nevertheless, considering that appellant did not interpose any objection thereto, and the parties and the judicial authorities or personnel concerned appeared to be familiar with or knowledgeable of Cebuano in which the document was written, such extrajudicial confession was appropriately considered by the trial court as evidence for the prosecution. As stated at the outset, the crucial issue in this case is whether or not the extrajudicial confession executed by appellant with the assistance of Attorney Fortunato Parawan is admissible in evidence against him. There is no need at this point to secure an official translation of the confession to English. So there, that was the ruling of the Supreme Court in the case of People versus Tumakin. Let us go now to Section 34, Offer of Evidence. The court shall consider no evidence which has not been formally offered. The purpose of which the evidence is offered must be specified. This is the general rule. There is no revision also in this section. There are two exceptions to the general rule. Evidence not formally offered can be considered by the court as long as they have been, number one, properly identified by testimony duly recorded, and number two, they have themselves been incorporated in the records of the case. I'm sorry for my voice. What happened in the case of People versus Libnaw was, babae po si Libnaw. She and her companion were arrested because of transporting marijuana. But before that, they were under surveillance. The case reached the Supreme Court. Libnaw argued that the documentary and object evidence presented by the prosecution at the trial court are inadmissible because they were not formally offered. However, the Supreme Court ruled this contention of the appellant as untenable because even if they were not formally offered, the prosecution can still establish the case because the witnesses properly identified those exhibits and their testimonies were recorded. And besides, Libnow's counsel had cross-examined the prosecution witnesses who testified on the exhibits. So that was the case of People versus Libnaw, which properly explained the exceptions to the general rule of Section 34. The rule on additional evidence after case is rested is that the rules of court does not prohibit a party from requesting the court to allow it to present additional evidence even after it has rested its case. Republic versus Sandigan Bayan. This is a civil case. In this case, the petitioner filed a petition to the Supreme Court claiming that the Sandigan Bayan committed grave abuse of discretion because the Sandigan Bayan refused the Bani deposition, which was already admitted as evidence in an incident case as a part of the petitioner's evidence in the main case. The Supreme Court ruled that the Bani deposition is not admissible under the rules of evidence as an additional evidence because it was not a newly discovered evidence. There are 7 instances when formal offer of evidence is not required. Number 1 is lost objects previously marked, identified, described in the record, and testified to by witnesses who have been subjects of cross-examination in respect to said objects. Second is on summary proceedings. Third, documents, affidavits, and depositions used in rendering summary judgments under Rule 35. Fourth is documents judicially admitted or taken judicial notice of. Fifth is documents whose contents are admitted by the parties. Sixth is documents or affidavits used in deciding quasi-judicial or administrative cases. And lastly, in naturalization, insolvency proceedings, cadastral land registration cases, election cases, and other cases where the rules on evidence do not apply. Take note that in number 7, this is expressly provided in Rule 1, Section 4 of the Rules of Court. Let's go now to Section 35. As you can see on my slides, the phrases colored green in the provision is the revision. Section 35, when to make offer. All evidence must be offered orally. The offer of the testimony of a witness in evidence must be made at the time the witness is called to testify. The offer of documentary and object evidence shall be made after the presentation of a party's testimonial evidence. Therefore, failure to make a formal offer within a considerable period of time shall be deemed a waiver to submit it. Consequently, any evidence that has not been formally offered shall be excluded and rejected. The time to make offer for testimonial evidence is at the time the witness is called to testify. For documentary evidence, it is after the presentation of a party's testimonial evidence and before he rests his case. As for the object evidence, it is after the presentation of a party's testimonial evidence and before he rests his case, unless it cannot be submitted to the court, in which case at the time it is presented to the court's senses. In the case of heirs of Cruz Zamora versus Multiwood International Incorporated, the Supreme Court ruled that mere identification of documents and the marking thereof as exhibits does not confer any evidentiary weight on the documents unless these are formally offered. On the other hand, in the case of Barrett versus People, documents which may have been marked as exhibits during the hearing but which were not formally offered in evidence cannot be considered as evidence, nor can they be given any evidentiary value. There are 6 stages in the presentation of documentary evidence. Number 1 is identification, wherein the proof that the document being presented is the same one referred to by the witness in his testimony. Number 2 is marking, wherein all exhibits should be marked to facilitate their identification. Marking may be done during the pre-trial or during the trial. Number 3 is authentication, wherein the proof of a document's due execution and genuineness is authenticated if the purpose is to show that it is genuine. If the purpose is to show that the document is a forgery, proof of its forgery is authenticated. Number 4 is inspection, wherein whenever a writing is shown to a witness, it may be inspected by the adverse party. Number 5 is formal offer. After the termination of the testimonial evidence, the proponent will then make a formal offer and state the purpose for which document is presented. And the last one is objection. The objection to the introduction or presentation of the document shall be made when it is formally offered in evidence. The last section of my report is section 36. It is an amended provision. Section 36 is objection. Objection to offer of evidence must be made orally immediately after the offer is made. Objection to the testimony of a witness for lack of a formal offer must be made as soon as the witness begins to testify. Objection to a question propounded in the course of the oral examination of a witness must be made as soon as the grounds therefore becomes reasonably apparent. The grounds for the objection must be specified. So what is objection? It is a formal protest raised in court during trial to disallow a witness testimony or other evidence which would be in violation of the rules of evidence or other procedural law. What is this other procedural law? It is also known as remedial law or the rules of court that comprises the rules by which a court hears and determines what happens in civil, criminal, lawsuit, or administrative proceedings. The amendment in this provision incorporates the ruling in the case of Katwira versus Court of Appeals. This is a case where the prosecution failed to offer in evidence the testimony of a complaining witness upon calling her to testify, and that the offer was made only after her testimony and after the accused had moved that the testimony be stricken off the record. The Supreme Court held that the procedural error or defect was waived when the accused did not object to the testimony when it was not first offered upon calling the complainant. There are 4 classifications of objection. First is the general objection or the broadside objection. This objection does not go beyond declaring the evidence as immaterial, incompetent, irrelevant, or inadmissible. It does not specify the grounds for objection. As for the specific objection, it states the ground upon which the objection is made. It also states why or how the evidence is irrelevant or incompetent. Formal objection is one directed against the alleged defect in the formulation of the question. Example here is ambiguous question. Those questions which are unclear. Lastly, substantive objection is objection made and directed against the very nature of the evidence. For example, it is inadmissible either because it is irrelevant or incompetent or both. The given examples here are parole and hearsay evidence. What are the purposes of objections? Number one is to keep out inadmissible evidence that would cause harm to a client's cause. The rules on evidence are not self-operating, hence must be invoked by way of objection. Number two, to protect the record. Example, to present the issue of inadmissibility of the offered evidence in a way that, if the trial court rules erroneously, the error can be relied upon as a ground for future appeal. Number three, to protect a witness from being embarrassed by the adverse counsel. Number four, to expose the adversary's unfair tactics. Number five, to give the trial court an opportunity to correct its own errors, and at the same time, warn the court that a ruling adverse to the objector may supply a reason to invoke a higher court's appellate jurisdiction, and the last, to avoid a waiver of the inadmissibility of an otherwise inadmissible evidence. Objection must be timely made. And in order to be timely, the objection must be made at the earliest opportunity. What the earliest opportunity means, it depends upon the manner of evidence offered. For example, the objection to offer evidence, it must be made orally immediately after the offer is made. If it is an objection to the testimony of a witness for lack of a formal offer, it must be made as soon as the witness begins to testify. And if it is an objection to a question propounded in the course of the oral examination of a witness, it must be made as soon as the grounds, therefore, become reasonably apparent. Take note that under the 2019 revised rules on evidence, the court no longer has the discretion to allow the formal offer of evidence in writing. As expressly stated in Section 35, it should be offered orally. Waiver. For a party fails to object to evidence when offered, he is deemed to have waived his objection thereto, and consequently, the evidence offered may be admitted. For a continuing objection had been interposed on prohibited testimony, the objection is deemed waived where the objecting counsel cross-examined the witness on the very matter subject of the prohibition. Extent of waiver for failure to object. A waiver should not be construed as an admission that evidence is credible. It involves no admission that the evidence possesses the weight attributed to it by the offering party. It does not also mean that the non-objecting party waives the right to present controverting evidence. It only involves waiver of objection to matters, namely the relevance and the competence of the evidence. Thank you and God bless. That ends